All right, great. Thank you so much. I am pleased today to be here with my two colleagues here. The first, I'm going to do introductions for both of them before I begin. The first is Alan Carlson. He's the former CEO at Orange County Superior Court in California. He's now retired, but he took over that position. He was appointed in 2008 until about 18 months ago. His career has included many years of court administration throughout the state of California, including 7 years as the Chief Executive Officer of the San Francisco Superior Court. He's also a member of the Board of Isles, which I will speak to a little bit more in a moment, but that's where I work, so I have the pleasure of working with him on projects there, which is wonderful. We also have today Dan Wallis, who's the trial court administrator for the 22nd Circuit Court of McHenry County, Illinois. He likewise has numerous years working within the court system, in addition to being a trial court administrator. He also works with the National Center for State Courts Institute for Court Management and holds a national certificate for court management through that institute. And again, it will come up later, but he is working on a demonstration pilot project in McHenry County, focused in large part on improving case management. So I'm excited to have him speak about his experiences there as well. And it's been wonderful to work with him on that project. So with that, I'm going to do a little bit of an introduction to provide some context and background for this discussion, and then I look forward to having you guys speak more than me about the issues of case management. I'm going to actually realize I don't have a clicker, so I'm just going to walk over here. Oh, let's see. See if they have it for me here, if it works. All right. So I can do it over here. So first of all, I wanted to just provide a little bit more background for those of you who aren't familiar with ILES, the Institute for the Advancement of the American Legal System. We are a research institute located at the University of Denver, and we are now about 13 years old, which is very exciting. We're in our second decade, and we are focused on improving the legal system, and we do that by focusing on a number of different areas, including civil justice reform, family justice reform, the legal profession and legal education, as well as the judiciary. So we work across the legal system to improve it, primarily in all the areas except for criminal, if you're wondering what's not on that list. So that is what we do at the University of Denver, and I'm excited to be a director there. And also, I wanted to let you know this presentation is kind of loosely based on a publication that we just had at ILES called Redefining Case Management. And I have a number of copies up here if you want to come afterwards and grab a copy. It's also part of your electronic materials. So to the extent we refer to that, that publication came out this spring. But really the goal of this publication, it doesn't have all the answers to redefining case management for the 21st century, but the real goal is to prompt a conversation and dialogue, which is why I'm excited to be here today to further that conversation about what our courts need as we enter the 21st century and modernize them in terms of case management. So from there, I'm going to start with looking backwards. So if we think about case management, I'm not going to go through the history of case management. We do a little bit, just a nod to it in our publication. But case management has really evolved over the years. And it was interesting, Alan spoke yesterday about artificial intelligence and the idea that you had a course touching on artificial intelligence back when you were in college. And I was thinking, too, about case management. We've been talking about case management for many, many years. So you've heard about case management before. It's not a new concept, but how we think about it needs to evolve for the 21st century and the current challenges and opportunities in our court. And there's a lot of new opportunities in terms of, I was again thinking about artificial intelligence, the amount of data that we have now that we didn't have 50 years ago, the technology that we have to really facilitate case management in a different way, and the current challenges that we have that we need to embrace. So rather than this idea and vision of case management as for those innovative few, for the courts that really embrace it, for the few judges who think it's a great idea, I think we need to move to a new vision where case management is something that all judges and courts embrace. And I would also argue that lawyers are an essential piece of that puzzle. It can't just be the courts. And from there, I just wanted to touch on those current challenges that we face as a court system. We have budget and funding challenges, which I know you are all very familiar with. Rising civil litigation costs and the impact on access. A lot of people feel that they can't actually go through a full case, get all the way to trial, or sometimes even get into court because of the costs. That's true as well with representation and the high numbers of people who can't afford an attorney to help navigate this process. We also have changes to court caseloads and filings. We actually are seeing a decrease in the number of filings, and that's something I know you both up here have experience with, and you can touch upon that if you'd like to as we have our discussion, but that's something that's facing our courts in terms of declining numbers in our caseload. But then, as I said, we also have advances in terms of technology. So we have a lot more that we can do in terms of case management that we couldn't do 20 years ago. I also wanted to just highlight the recent recommendations that were adopted by the Conference of Chief Justices and COSCA. So these now, going back 2 years actually, were adopted back in 2016 as a result of a committee that spent a couple of years working on developing these 13 recommendations for reform. We at ISLES were excited to work on these along with the National Center for State Courts in support of this national committee. And those 13 recommendations highly touch on case management. And in fact, the first recommendation is that courts take responsibility for managing civil cases from the time of filing to disposition. And this core principle that the courts themselves, rather than leaving it to the attorneys or the parties, need to be the ones responsible for moving those cases through the process. That we can no longer leave it to the attorneys, in large part because there aren't attorneys in every case, and in large part because the court is the one who can take responsibility, who has the information, who can see across the whole docket and help manage those cases. So I wanted to highlight those. Those are also in your materials. So from there, what is our new vision for case management? That's the question here for our discussion today. I would argue that it is first and foremost court ownership with a capital C, so also judges, everybody in the court system owning case management, and also managing in service of the user, which I think is a great piggyback off of our last session. So if we think about embracing court management, case management in service of the user, we can think about providing that consistency within and across cases, providing right-sizing the process for the needs of that case and the litigant, procedural fairness, and increasing public trust and confidence. So those are all key aspects of case management. And I also wanted to know this fits right directly in with NACM's core competencies. I thought it was really interesting in looking at these that the core competencies are put into 3 categories of vision, principles, and practice. So in terms of vision, leadership, strategic planning, and court governance, principles of public trust and confidence and strategic planning, and then the practical in terms of case flow and workflow. And we'll also probably touch on workforce management and court performance. And so I think all of these actually come together in a really critical way to think about what does case management look like going forward. So with that is the question today is, how do we redefine case management in light of the above? And I'm going to start by tossing this over to Dan to kick us off.
To me? Good morning.
Good morning again.
So in the over the last 18 months or so, the 22nd Circuit has really started to take ownership of its case management as it relates to civil justice. It started really as a small conference that we hosted in Northern Illinois, the Second Appellate Conference, where all of the courts in the Second Appellate got together. And the report had just been released from the Conference of Chief Justices, so it was brand new. And so we had Judge Jerome Abrams, thank you, from Minnesota come down. And we also had Paula Hannaford come out to talk to us about it. And my chief judge was very receptive. And I have been pushing court management, or case flow management, since probably 2005, and really hitting some of the older methods as much as possible, differentiated case management, and it never really took hold. It never really, whenever I had these conversations, judges would just shy away from case management. The case belongs to the attorney, not the court. They know the case better. So why should I be the one that pushes things forward? So we decided to enter into a competitive, I'll call it a request for proposal or a grant process with the National Center, partnering with IELTS to really start looking at what we can develop and what we can do different. So we were awarded the grant, and one of the first things that we needed to do is take a look at our own landscape. The landscape study does everybody know what the landscape is? I'm seeing not a lot of nods. Okay. All right, let's step back for just a second then. Okay, the landscape study was actually done in 2015, I believe. And in 2015, they looked at 5% of the civil cases across the entire the entire country, okay? And they looked at metropolitan courts, they looked at, I know Cook County was involved in it. And what they found was disturbing, in my humble opinion, disturbing. And this is why. I gotta be careful too here. Not a whole lot of litigation was taking place in these cases. Very little litigation was taking place in these cases. And it was taking a long time for these cases to be resolved. So one of the first things, and this is me as a court administrator talking to you as court leaders, don't be afraid to do your own landscape. Use the metrics that are out there. The court tools are an excellent starting point. Start looking at what's going on actually in your court. That way, you know what's taking place. I did my own landscape study. I looked at all of our civil cases over a year's period of time to see what was going on. And here's what I can tell you. In McHenry County, we've seen almost a 50% reduction in civil caseloads. Would you believe it takes longer now to get a civil case through the system? So the caseload goes down by half, but it takes longer to get through. Guess what? That's exactly what the national landscape says. It costs too much and it takes too long. So we did our landscape. We got everybody together, had all of our presiding judges come in. We had invited members of the bar. IELTS was there. The National Center was there. We had the clerk's office there to start talking about these new initiatives and how we could develop case management teams. And right away, whenever you start talking about changing the system, you get the wall that comes up, right? Nobody wants to do it. You know, it's never going to, why do we need to do it? I have one judge who said this was a solution in search of a problem. Well, I beg to differ. This is a solution to a problem that already exists. We can say it doesn't all we want, but the data and the research says that it's not true. You know, that it's, there's a problem here. And we as court managers need to be willing to step up and take a swing at this problem. So we did. And when we did, again, there's pushback. But over time, now that we've been doing this for about a year, we're starting to see what some of these little nudges in change management are starting to take place. I have two theories when it comes to change management. I can picture an ocean liner, and it's on one side of the harbor, right? And we want to take it from here and we want to put it over here. We have two ways that we can do it. We can give it one big push, right? We can shove it. Well, I can guarantee it's going to make a lot of waves. We're going to break some dishes, and we're probably going to upset some people, right? Or we can start with little nudges, right? And before you know it, the boat's over here, the view's changed, and everybody's going, well, gosh, that wasn't so bad, and look at this view. It's better than it was before. So that's what we're starting to see is some of our little nudges starting to take hold. We've developed our case management teams. They involve the judge. We now have a case manager who screens every case that comes in. We also have involved our attorneys. And would you believe the one that's the most interesting is the attorneys? Because when you start talking about delay reduction, you're talking about really their wallet, because they bill every time they come to court. Well, we went from having this absolute resistance to now the attorneys, not only are they in favor of being accountable, they want us to be make them even more accountable to time standards. We've developed our pathways. We've now automated our triage for, which actually we just started doing that last week. Just started automating our triage of cases. When a case comes in, what pathway does it go in? We're actually putting that on the, as a data field within the case management system so we can run reports off of it. The other thing too that we were able to do is put it on our attorney portal, which is a front-facing portal on the web that attorneys can actually see what pathway is this in, what does it mean, what's the timeline, what's the next event, and what they can expect. So again, we've been doing this for about 18 months. We've been implemented in the project for a year. We're still working through. We're also the only court that's implementing all 13 of the recommendations. So we didn't take just developing teams, we took all 13 and implemented them. So I'm looking forward. We're going to be starting a review process in September, starting to look at data to see what we've accomplished. I have some ideas that we've reduced the time to disposition, but once we start looking at the data, then we'll start to understand a little bit more what's actually taken place. But philosophically, I can say that is occurring. I know, and we did it across all civil cases. And one of the other things too, as we were developing the pathways, judges and attorneys originally wanted everything to be complex, right? Everything's a medical malpractice, everything's a legal malpractice. There's 18 defendants and there's 22 attorneys, right? No, there's not. 2% of the caseload's that. Make your system for 98%. Make your system for 98%. That's the reality. And again, we're testing our own reality, we're pushing our own reality, we're trying to make a difference. And why? Case management's what, and this is, coming from me and my education, my background in court management. Case management's what we do. These are people. We should be, we've been talking about mindfulness for the last 2 days and procedural fairness this morning. It's what we do. I want to make a difference in my court. And I'm hoping that being part of this project, presenting to you this morning, that you too will start to understand and have a little interest in case management and know that it's something that's active. Case management's not passive. Historically, it has been. Even back into prior to the 2000s, it was very passive. So we're making progress. I hope next year we'll be able to share a lot more information in detail as far as re-look at our own landscape. But so far, I believe we're making some changes. We're looking forward. We're not looking backwards. So.
Great. So I'll turn it over to you, Alan, to maybe look backward a little bit in terms of where we've come.
Good morning. I'll take a little bit of a long view and start going way back, but also I want to look a little bit forward about what I think we need to be aware of and think about in terms of case management. So at the beginning of my career, and it's fun to say last century, I was lucky enough to be part of a team that was looking at the process of cases, the pace of litigation. And it was the first big empirical study. We looked at 21 courts across the country. We collected exactly the same data in all 21 courts, and then compared them and said, what's the difference? Why are some courts faster than other courts? And the net of that was, it was judicial control. We had empirical evidence that showed if the judges manage the cases, they go faster. Not about caseload, not what mix of cases you have, not how big your jurisdiction was, not how many judges you had. All that stuff had nowhere near as much effect as what the judges did in terms of managing the cases. So we produced a report called Justice Delayed that said this. It was also the original source of the concept of local legal culture, and that's a whole nother story. It was fun how that came up. To say, look, your local legal culture determines how you process your cases, and you got to pay attention to that, not the procedural rules, not the rules of court or the civil procedure rules for the state or something like that. And eventually, it took a few years later, the concept of differentiated case management came out of that same process as we tried to figure out, okay, how do you actually implement what we found in terms of the studies? 2 other studies were done subsequent to that by the National Center. The first one, I was working at the National Center. So there were 3 studies over a period of, I don't know, maybe 15 years that all said exactly the same thing. And one of the studies went back to the same 21 courts and found the same thing. So there is really solid empirical evidence out there from way back saying case management makes a difference. We were criticized, though, not surprisingly, initially. All you care about is pace, how fast things go. But this is justice. You can't hurry justice. Understandable, it's the change thing. And the second thing was, well, judges aren't supposed to manage cases. They're the attorneys' cases. They're not our cases as the court. The attorneys know them better. They know how to control things. And the rebuttal was, okay, pace, you're right. It's not the only thing, but it is something. And if you have slow cases, you don't have justice. Justice delayed is justice denied. And the issue is how delayed can it be and you're still getting justice in some sense. So there wasn't a lot of initial take on that. I sometimes think we were throwing the seeds on rocks instead of in a field to grow. And I sometimes joke with Brittany, this is deja vu all over again with case flow management. There's like 4 times in my career where case flow management has come up. This time it seems to be sticking better than the other times, which is nice to see. So that's what I want to talk about, and why Brittany asked me to do this is, so what's different now from when I started on this in terms of talking about case flow? And there are a lot of things that are very satisfying about this, that we've made progress. As was mentioned, the judges get it now. And what's interesting is if you have judges, they used to be lawyers, and when they were lawyers, if they were subjected to case management, when they become judges, they remember that. And we had a huge delay reduction program in California that kind of turned everything in terms of the attitude. And you see it in new judges. I mean, I was always happy to have a judge come from a big law firm that had done a lot of big cases because they got case flow management, because they had to do that as part of their cases that they were processing and that sort of thing. So you got acceptance now by the judges better, not everybody. And you have better acceptance by the lawyers because they get it, that this could move things along and not stall things. And yeah, it affects their bottom line, but that they seem to have gotten used to that with funny little exceptions. As mentioned, the caseload went down, and in California, interestingly, when we changed to delay reduction and imposed timelines, the very first few months after it went into effect in January, the caseload dropped like 25% in civil cases in the general jurisdiction courts. So we thought, well, that's fine. They're small cases. People said it's not worth going through the procedures we have in Superior Court. They would go in our municipal courts, the limited jurisdiction courts. So we went and looked at the filings in the limited jurisdiction courts, and no increase. 25% of the caseload just disappeared. I have no idea what happened to those cases. I've always been nervous about what happened to the people who used to file those cases but wouldn't file them because of the Delay Reduction Act. And I don't know what that is, and I'm going to touch on this again at the end. So judges going along with it, the attorneys going along with it, but also it's important now to me when the terminology in the report says fair, efficient, and accountable, not speed. And then other places it talks about just and expensive as well as speedy. So we're getting that it's not about speed. It never was just about speed, but now everybody's understanding that, okay, it's fair and just. It's better when there's faster case processing. You're not wasting judicial resources on churning cases, and it's not taking too long and costing the litigants more money. I think the other part I really like is what's now called proportionality, and this is a newer concept. And frankly, it came about, I think, as a result of e-discovery. When you suddenly had all these electronic documents and everybody was plowing through them, the lawyers, we weren't. We were kind of waiting for the lawyers to do all this discovery work. And you have massive amounts of documents, and how do you go through all these documents? And the amount of money to spend to go through the documents is more than the case is worth in the first place. Something's not right here. And you end up with this concept of proportionality saying, well, what's reasonable in terms of discovery? And I think the courts have now gotten into it, and part of what's going on here is it's proportionality as to what case track you put things in. Does this case really need to be a complex case? No, it's not really always a complex case, so put it on a faster track to do things. But proportionality now, I think, in discovery, there's more judge involvement in this, saying, in the conferences, for example, do you really need to go through 10,000 documents? Can you figure out some way to, what's really important to do that? And again, artificial intelligence apparently is playing a role here with the lawyers. I wasn't even aware of that, but Brittany's had some experience with that. In the consistency issue, I was a little nervous. A lot in California, we had master calendar systems, and when we went to delay reduction, everybody said, no, individual calendar is faster. Not true. All the data shows that's not true, but that's the perception. So I thought, okay, my problem with that is, do we have less consistency? Because now every judge is going to do their own thing. But it turns out if you have the case management teams and the case management computer systems and the tracks, and you're telling lawyers what it is, you can actually get better consistency than we used to have under whatever system you had in the past, that the direct calendar, individual calendar doesn't necessarily make it worse in that kind of a sense. So I want to shift now, looking a little bit forward, and I didn't talk to Brittany about this, so I'm going to surprise her as well, because I thought of this just in the last few days. So if you look at the courts as a business, and businesses are trying to sell things or do something, you have a product you're selling. So what should we be doing in terms of, or what should we be worried about in terms of our work? Now, if the caseload's going down 10 or 15%, if you were in a business and your volume was going down 10 or 15%, you'd be worried. Should we be worried that we're not being used by the citizens? I think there's an issue there, but I don't think it's just that by itself. It may actually be okay that we're not being used as much if people have found other ways to do things. There's alternative dispute resolutions. There's mediation systems. There's online dispute resolution systems. So people have alternatives to using our system, and they seem to be taking advantage of it. That's probably okay. I don't like the term alternative dispute resolution. I like to call it appropriate dispute resolution, because that focuses on what's really going to work in this particular case. If you have businesses, for example, that have been doing business with each other for years, something goes wrong in a contract, one of them sues the other one, now you're suddenly in an adversary system. But these people have had a relationship that goes on for years. Maybe a mediation is better because it can maintain that relationship or take advantage of that relationship in terms of working out a reasonable solution to doing things. So I'm not so worried. I'm a little bit worried about ADR, ODR taking our work away from us. How could we, government always wants less work in one sense because your resources don't change with your workload, up or down, in my opinion. So that's an issue. But the other ones I'm more concerned about are the mandatory arbitration clauses that are now everywhere. And so you know where the source of this is. There's a federal law that says if somebody wants arbitration and they agree to arbitration, that overrides anything else. You can't take it to court. If you got an arbitration clause, you have to go to arbitration. And of course, nowadays, nothing is opt-in. Everything that's your choice. Take it or leave it. And I think a lot of stuff is now being arbitrated or just not being done because people don't want to use arbitration. That's reduced our caseload. And that's a problem because now people are saying, I can't get justice. I can't even get to the court because I've been cut off by these arbitration clauses. And they're showing up all over the place, particularly in work situations and that sort of thing. So that's not a good reason to have less work in the system. So if we have better case management systems, we're doing a better job of litigating, maybe people will come back to the courts. And we're going to increase our business. And then the final thing is the recognition of self-represented litigants. What I find weird about the landscape is they discovered that 70 or 80% of our cases, if you look at all civil cases, don't have a lawyer on at least one side. I've always known that. The whole time I've been in courts, not just 3 years ago. But it was because it was in the limited jurisdiction court, which we didn't pay attention to in some levels. So I think it's a good thing that we're paying attention now, except that's a whole different class of people. We're not dealing with the lawyers, training them. We have to figure out how to deal with self-represented litigants who are generally speaking one-off. So it's a whole different deal than lawyers. Lawyers, you can train them and they're coming back. They're going to have cases regularly. So you can train them to work the system. That's not true with self-represented litigants for the most part. So that's a different way now of looking at case management. How do we deal with the people that are in front of us, not the lawyers and the cases? So that's historical and forward on perspective on things.
Thank you, guys. So maybe I'll start high level, and then we'll go to questions that are more specific. So you both touched a little bit on culture change and how do you move toward embracing the role of courts in case management. My question is, how practically do you do that? It sounds like you've had great experience over the last year, but what does that look like? Because as I've worked with courts around the country, some have a local legal culture where that is the culture. The judges and the courts drive case management. But I also talk with a lot of courts where they still aren't there yet, and they're very hands-off. They feel like it's the role of the attorneys, and so I'm wondering, we might have a mixture of people here. How do you get there?
Changing your own local legal culture, it's all about conversation and relationships. That's been my experience, that you need to first have somebody who's the leader, in this case my chief judge, who's willing to take a stand for the change that you can sort of point at as a court manager. Also, as a court manager, you need to be able to have the relationship with your judges to have very frank discussions about what's truly going on within their courtrooms. I'm not shaming any judges or pointing out flaws of judges, just showing them what's actually going on. When they're on the bench every day, pedaling fast, trying to move cases along, they're dealing with the attorneys, they're dealing with their self-represented litigants, they lose focus as to what's actually happening in the courtroom as a whole. Well, that's where my role as a court administrator, I'm the one who's looking at that very broadly, the forest through the trees kind of aspect. And then being able to, again, have those conversations, whether it's with the attorneys, whether it's with the judges, whether it's with the clerk's office, being able to pick up, go in, have those conversations, be very direct, use data, because we've all heard about data-driven decisions. It's no different with courts. If I can say without a doubt that it takes longer now, or before we started the program, it took longer to get a case disposed of. Why? Because the data says so, and I can point at it. And that's not something that anybody can run away from. It's the fact. So that's where I start.
I got a couple anecdotes. So one option is a try it, you'll like it kind of a thing. And some of the delay reduction things we did in California, the statute that changed things required the 8 largest courts to do it. And then whoever else wanted to could do it. And we ended up with 20 courts out of 58 that tried it, which was a pretty good deal. It was interesting that as I said, the 8 largest courts were mandated, but so that means the other 12 were mid-sized courts. And I thought it was interesting that the mid-sized courts tried it. And sometimes they got farther faster, and we were able to point to the mid-sized court saying, look, it works in Mendocino or San Joaquin. Why can't you do it in LA and Orange, kind of a thing. So it's kind of like, if you try it, maybe it'll work. The fun one we had was in Orange, we shifted to complete electronic records, no more paper files, and e-filing. So at some point we got to the point where we were telling the judges, you know what, no more files. We're not going to have files. New cases, no new files. And then we scanned the old ones, so there were no paper files anywhere. We gave the judges big monitors on their desks with touch screens to find stuff. And not surprisingly, we had some older judges who said, I don't want to use the computer screen, I want to do it on paper. And thankfully, the presiding judge said, you know what, no, we're not going to have special rules for judges about the paper. And if you don't want to use the computer screen, we have some other calendars you can go use, and you won't be in civil anymore. You'll be doing juvenile, family law, or even smaller cases. California, they only have 1 court in the county, so you have everything from small claims cases to complex cases in the same court. Not a single judge said, okay, I'll take some other calendar and not use the computer screens. But more interestingly, not a couple of months passed when at a judges meeting of the civil judges, who the ones you would have thought were doing this, they were meeting with the staff, and it was set up to do this. I want this moved on the screen to here. and I want to be able to see this way. Can you put a button here that allows me to see the pleadings, just the pleadings in the case? So, try it, you'll like it. And you go through a little resistance initially, but if they see the advantage of it, they were fine with it, and there were no complaints eventually about doing that. So that's another way to I don't know if you're always going to have a presiding judge that's willing to stand up to all his colleagues. This fellow was, to say, this is the way it's going to be, and if you don't want it, I'll put you on some other calendar. That's a pretty tough statement to make, and they're elected judges. But it worked. So keep an open mind about doing things. And maybe you find a few judges and you start with a few judges and they're your pilot people. And then, Mikey likes it. The other people will start doing it.
All right, and you both touched on use of data. So that's something that I think is an opportunity that we have that we didn't have 20 years ago. So if you guys could talk about how can we use data to drive case management in a way that we never did before?
Sure. Thankfully, we in McHenry County have gotten very good with our technology. I mean, we've been e-filing since 2013. We're moving to e-record, e-signature. We're doing everything we possibly can. One of the things that, especially with our automated triaging, is being able to tag cases for what pathway they're on, whether it's an expedited, standard, or whether it's a complex case. So we're now able to use that data element, or we will be able to use that data element to run reports. This case is in this track, or in this pathway. This is how long it's taking to get this case resolved, and being able to provide time to disposition reports, the age of the pending caseload, clearance rates, trial date certainties, continuances, all of those things we're able to provide to the judge. The other thing that we did prior to implementation of the project was we implemented a judicial portal, an e-bench solution that allows judges to see exactly what they want to see, how they want to see it. Very configurable, can move things around. And how we went about that implementation, this goes to your point, Alan, that some of the judges really didn't want to touch it, but as soon as we implemented it, the implementation was so smooth because of how we implemented it. I had judges involved in the building of the RFP, and had judges that were involved in the actual implementation plan, that when we implemented it with our 5 judges, the other judges wanted it. We took a three-year program or project, condensed it to 16 months, and implemented it to all the judges. And now the judges are so used to getting the reports, they're so used to getting the information, and they can come to me and ask it, if there's a report that needs to be, maybe tweaked a little bit or changed so that they can get exactly what they want. We have personnel that can do that on the fly. So it's become almost the norm in my court to utilize the technology that way.
A point that you're bringing up, whenever we had a project that involved electronic stuff and judges in Orange, like building the judges portal, we always had a judicial sponsor. There was always a judge that worked with the committee of staff to do this. It wasn't like the staff went and designed something and then showed the judges at a meeting, here's what we built for you. No, it was always, here's the system that was built for you with the help of this sponsor judge and maybe 2 or 3 other judges that volunteered to help do this. So it wasn't something we were giving them, it was something their colleagues had developed. Mm-hmm. And that judicial sponsor concept is a really powerful way to get particularly technology things going forward. Another quick data story. So when I first went to Monterey County in California as administrator, you always had reports you sent up to the administrative office every month, but the judges didn't always see it. So we had monthly judges meetings. At one point, shortly after I got there and realized nobody had any idea what the caseload was, I put together a 1-page report that said this is how many filings and dispositions we had each month by case type. Fit on 1 page. Just filings and dispositions, civil, criminal, family, juvenile, kind of thing. And I said, here's what's going on. Tell me what else you want to know about these numbers. So within a year, the monthly report was a 14-inch wide paper. The first column was filings and dispositions for that month. The next column was the average filing and dispositions for the last 12 months. The third column was what was the same number a year preceding, because we could see some seasonal stuff. And then the rest of the thing was the filings and dispositions for every month for the last year. And it was completely designed by the judges. I would say, what do you want to add here? Or I would go through something and say, well, the filings are up here compared to before. And they say, well, how much? So, okay, we'll add that row so you can see how it's changed over time. So that was valuable because now every month, and it was the first thing we talked about at every judge's meeting. They had to put up with Alan saying, here's what the filings and dispositions were last month. And after a while, it was fine with them because they were asking questions about what's going on. Then something happened that I had never anticipated with this, but now that's why I'm telling you, is I would say one month, okay, felony filings are up 15% last month. I don't know what's going on, raids, whatever is going on, but they're up 15%. Next month, funny thing, the dispositions were up 15%. Because they knew that there was more work out there, that next month they worked a little harder, and it wasn't always 15 and 15. But they got it, that if you didn't keep up with the filings, it was just going to pile up on you. Oh, pending number was one of the columns that got added as well. So you start using the data with the judges, and they'll react to it. This group did. I mean, they did. That dispositions went up the next couple months if the filings went up. And we started noticing, my favorite always was juvenile. So kids are in school and they're behaving themselves, and then when it gets close to the end of the school year, they're bored, and juvenile crime always climbs in May and June. And then it drops when school's out, because they got something else to do. I don't know. I mean, but it goes up again at the end of the summer because they're bored with summer, and it drops again when school starts. You would have never seen that unless you were looking for several years at every month and what's going on in the filings. You can do a lot of things with data, even though it sounds boring or whatever. And I know, I mean, I'm an engineer. I love data. So that's part of my problem. But I could get the judges to actually use this stuff.
So how about pushback in terms of transparency? So I think we all three are data people. But I think that varies by person, and I find that it varies by jurisdiction around the country, and sometimes also whether judges are elected or not. Sometimes there's a little bit of pushback in terms of transparency. So what are your thoughts about that? Both court data, maybe by judge, and how to move that conversation along?
That's a great point, Brittany. Some of my judges that are involved in the Civil Justice Improvement Project are concerned about how's this data going to be used. And I am of the opinion, and I have been since I started my trek with the National Center through the Institute of Court Management, that we need to be accountable to the people that we're there to serve. And that being the case, we need to be willing to talk about what's truly taking place within a court system. And it doesn't matter who you talk to, it's just that you need to be talking. And being accountable and willing to share the good, the bad, and the ugly as it comes to that data. I have no problem, and I've done this, and actually right after the first of the year I'll be doing it again. I will be sitting down with my funding agency, a board of county board chairmen and our county elected officials to talk about this project specifically and what it has done. You know, we went to them, we pitched this idea to them that we will save their constituents money through the court process by delay reduction and cost for litigation. So once we're done with our evaluation after we've been doing it for a year, let's have a conversation about what worked. Don't run away from it. And again, if we're not willing to take that look ourselves, I can guarantee that your funding agencies and your agencies that are outside of the court are evaluating you, right? I know that. They're using metrics that don't make sense. So you might as well use the best that you have and be willing to have that conversation, because here's the thing. If you're willing to have the conversations and the discussions, again, you're building that relationship with the other branches of government, the other funding, your funding agency, whatever that is, whether it's the state, whether it's the county. it will make a difference. You're not just standing there with your hat in your hand asking for dollars. You're entering into that relationship with them where you're independent as the judicial branch of government, but you're also interdependent. And so share the information rather than having them come look and finding something and using something different.
Looking internally in a transparency sense, so I don't remember the number, I had 15 or 20 civil judges in the civil department doing the larger civil cases. And they were all on individual calendar. They each had their own caseload. And there was one judge who was a supervising judge for civil, and we produced every month for him a chart or a set of tables that showed exactly how many trials each judge had done the last month, how many pending cases they had, how many new filings they had, and some dispositive motions, summary judgment, the things that took up a lot of judge time. The supervising judge's copy had all the judges' names on it. The one we gave out to the judges when they asked, and sometimes at a meeting, didn't have any judges' names on it. And that was our kind of compromise, which I was never comfortable with. But the peer pressure works because pretty much they know who's who on that list. They know what their own caseload is, so they know where they are on that list. And then they kind of know who the judges are and the other ones. And the fun part is once I showed a list to a lawyer, bar president, litigator, and said, tell me who these judges are. And he was pretty close. He was about 60% guessing who the judges were that were slower, had bigger caseloads, took longer to do dispositive motions and that kind of thing. So even though we weren't publishing that list, and ironically the paper never asked for it, which always surprised me because they were certainly entitled to it under our privacy laws or public access laws in California. But it still can be powerful even without names on it as peer pressure because people know where they are on the list and they say, wow, you mean I got the highest pending caseload? Maybe I need to do something about this. And if you transfer, every once in a while we move the judges and you transfer it and somebody says, I don't want his caseload. I'm gonna have to work really hard to get it down to where it ought to be because that judge wasn't doing a good job. And that got back to the judge who was moving. So there's a value in having that data. It's not, as I say, it might be marginal, it might be nudging kind of stuff in some sense, but it definitely works.
All right, so we talked about data. How about people? You've talked a little bit about case management teams. Just a little bit more background about that. One of the recommendations that are in those 13 CCJ COSCA recommendations is to utilize a team approach and case management teams. There's been a publication from the National Center for State Courts that focuses specifically on case management teams, and that's also in your materials. It's called the Civil Case Management Team Guide. But I know you're working on that in your court, so what does that actually look like, and how is it being implemented?
That's been one of probably the most interesting things. When you start talking about teams within the court organization, especially when you're involving judges. Now, we made it real clear from the very beginning that the judge was going to be in charge of the team, right? Judges want to be in charge. So with that, then we started to branch out and we looked at our local bar. We looked at the bar that typically, we're about 65 miles from downtown Chicago, so a lot of our civil litigators come from the city. So we involved them. We also involved our clerk's office. And then we involved court administration, and we actually went to our funder, which is the county, and then they funded a position for us, partially with grant dollars and partially with county dollars, to have a civil justice case manager. And they started getting together, and we implemented it across all of our civil courtrooms, our mortgage foreclosures, our law cases, our money damages, and then the small claims as well. And so all the judges were involved. And it was interesting to see the different teams, because we did it by courtroom. So my one judge who does probate, he has a team. The judge who does mortgage foreclosure has a team. The different dynamics, because the mortgage foreclosure team wants to do more education with the litigants, because again, as you know, typically there's not you're dealing with self-represented litigants on the mortgage foreclosure side. You know, what information can we push out? What can we do? And we're actually doing a study. We've got a control group that we're not sending information to, and then we've got a group that we're doing information to see what that difference is. And then on the on the probate side, everybody just jumped right into it. Once we got past the initial shock, oh my gosh, you know, how are we going to do this? To the point where let's try this, let's try that. We're getting input. We're trying to implement, you know, small projects under the grand umbrella of the Civil Justice Improvement Project. You know, dealing with guardianships and reporting. You know, we're now writing software that's going to be on a front-facing portal, so people that are doing inventories and the conservatorships can enter that information, flag it if there's issues, get it to the judge so that the judge isn't spending a lot of time. Again, because the judge's time is the most expensive time that there is. It's also can be the least available time too. So if there's things that we're able to do with our civil case manager, we're implementing and looking at processes, individual processes, and having those conversations collectively within a team. So it's been tremendously exciting, and for a court nerd like me, I mean, it's just totally fabulous to see this change in the paradigm, the shift into how the business is done.
I think that the half of you or more are thinking, well, I may not be able to talk my funder into doing this, or where am I going to find the staff to do this? One of the things about going to an electronic system is that you can free up resources. If you have e-filing and the stuff's coming in and you're reviewing it, that takes a couple of minutes per case, and then it's automatically going into a document management system and feeding your case management system. And then when a judge wants to look at a file, he just brings it up on the terminal. Suddenly you have fewer people at the front counter. I went from 17 windows to 3 at the front counter when I mandated e-filing. No paper files. I had 10 people who did nothing but move files back and forth between the central file room and the courtrooms. So there are ways to free up people to do case management, and we were able, because of this, to add a case manager type person in every individual calendar courtroom on our civil side because of this. And there were fewer of those than there were that I saved. I mean, 17 windows to 3 and 10 to 0. I didn't need that many people to have case managers. So you got to look at what advantages you can get out of an electronic system to save resources and then be able to redeploy them. I think the second thing is you change the kind of people you have. I mean, the most interesting thing to me was, and I studied a lot of anthropology when I was younger. So you have somebody at the front counter that's taking filings across a counter. They're dealing with people every day. You want them to be friendly, all the things that Judge Pratt was talking about this morning, about how they treat people that come before them. And that's the kind of person you want, the skill set you want for somebody who's at a front counter taking files, taking documents. Somebody who's doing e-filing, review, sitting in a cubicle, nobody else around, no interaction with people, they're looking at a screen. That's a whole different type of skill set. And you can't take the front counter people and put them in front of a screen and expect them to stay sane for too long a period of time. So you got to think about the impacts of that kind of a thing on the people that you're doing. But what we found, and I'm sure you found the same thing, the new kind of work is more interesting. And the staff like it better, and they feel more a part of things because I'm helping the judge and I'm helping these cases move along. So you actually get a better workforce out of it when it works than you had when it was all paper. Paper is, I mean, I think back about what we did with paper. And I've worked in some courts consulting where they had a team of people whose job was to find the misfiled paper. And they had half a dozen people who did nothing all day long but look for misfiled papers. Mm-hmm. Including, in one case, they said finding him in a judge's trunk in his car. That never happens with e-filing. You can't misfile a paper, a document in e-filing, because of the way, if you set up the way it comes in the correct way. I can't imagine all my life working as somebody who goes around finding missing documents. That would bore me to death. Okay, so I'm a nerd, I get that part. But still, a lot of people are going to be a lot happier being a case manager than they are chasing files, kind of thing. So it does make a difference for your workforce about who they are and how happy they are.
Sure.
So I think you guys both have had the excitement of working in a court that has technology and the ability to do all these things. Do you have any thoughts or takeaways for those who are sitting in the audience who don't have e-filing yet or who are moving there? Or what can they do in this interim period where they're still trying to catch up?
That's hard.
That is a hard one. Yeah, I would just encourage you. I really would, because I came from a court in Ohio, gosh, almost 20 years. Well, I've been in Illinois 10 years now. So, I left there 10 years ago. And we did not have a lot of technology. We just had moved to a case management system, and the server was actually a computer. I mean, it wasn't a server. And e-filing, forget it. Imaging, forget it. It didn't exist. But it's out there, and courts are slower to evolve than societal expectations. I'm sure that most of you have one of these, right? So what can you do on this thing? Well, I can order my groceries, I can get an airline ticket, I can check the weather, I can do everything. Society expects the courts to be similar and be accessible using technology, and in all types of technology at that. And because it is an expectation, it's one that the court is going to have to accept. And if that means a multi-year plan to get to technology, then that's what it is. And again, relationships are going to be key here. Relationships with your clerk's office, with your funder agencies, and put it on a long-term plan, but have steps along the way and generate those short-term wins so you can see that return on investment. It's how you're going to have to just progress through the process.
So I have a friend who's a judge in a tiny court in the Sierras in California. We actually have 20 counties in California where there isn't even enough work for one judge, or barely enough work for one judge. And the other end of the spectrum is LA has, I think, 624 judges or something like that. So I would kid with Ira that what we should do one Friday afternoon is pack all the files in his file room, everything, put it in a U-Haul, drive it down to Orange County, and spend the weekend scanning his entire caseload onto CDs or whatever, and then drive back Sunday night and plug the CDs into a computer, and now he's electronic. Now, we joked about this and drank wine about it, but it's actually not a completely crazy concept. If you can figure out how to do it, and maybe some states where you're having more of a statewide thing. California's, we have 58, we call them Hanseatic states. Notwithstanding we're a big state, we're pretty independent in each of the courts. But if the state can, I said, you should set up a deal at the state where the state just goes every month. They do it one of these tiny courts and make them electronic. And you can now get software as a service for your case management system. Some of the vendors, you don't need a computer system, you don't need a techie, you need terminals, computers, but you're using the cloud. And you store your stuff in the cloud, and the software's in the cloud, and they maintain the software, and it runs 24/7. I think we need to look more at how to get from, and that's a leap. I don't want to minimize that, from paper files to electronic files. But I think that we need to look more at that and maybe have a strike team in some sense in a state where you go around and just one by one just get everybody over into the electronic formats. And I think some states are doing that. Utah and Oregon, I don't know if the folks are here, where that's easier. It's a little harder in a great big state, which is weird, but true. Big states are like aircraft carriers, small states are like frigates. You can move a frigate faster than an aircraft carrier sometimes. But I feel sorry for smaller courts sometimes. It's just not as easy. It's not the same, and you don't have the same, you can't save 10 people, you only have 10 people in a small court. So it's, you're saving portions of somebody's time, not a whole person's time to make a change like that. So it's not easy.
I just looked down and I think we're right at our time, so I apologize we didn't get to questions, but I do want to highlight two things. The first is that for those of you who are intrigued by the idea of doing a landscape study on your own courts, on the National Center's website, it's ncsc.org/civil. There's a whole set of tools that have been created to support these efforts, and one of them is a DIY landscape guide, so it will walk you through what you can do in your own courts to gather this data and utilize it. So I encourage you to do that. And then also, there's copies of the publication up here if you would like to take one. So thank you all so much.